Good evening. Welcome to our webinar series on China's law and economic governance. My name is Angela Zhang. I am the director of the Center for Chinese Law at the University of Hong Kong. Today, I'm very pleased to introduce two guests to our talk today. Nathan Mabubi, he's a research scholar of the Center for the Study of Contemporary China at the University of Pennsylvania, as well as a lecturer in law at Penn Law School. So Nathan will be our speaker for tonight, and he will bring to us his latest research project on China's legal reform. I know Nathan quite well because we regularly see each other through a lot of the US-China exchanges, and he's very active in hosting a lot of events, including the CSCC podcast, as well as there's a recent 政法委 clubhouse events that he regularly hosts. And I highly recommend these events that Nathan has been moderating and organizing. And Nathan's primary academic interests are in the areas of administrative law, comparative law, and Chinese law, and which is going to be the main subject of his talk today. And his current writing focuses on the development of modern Chinese administrative law. And Nathan had taught at a number of universities, and before he joined academia, he served as a trial attorney in the civil division of the US Department of Justice and had served as a law clerk for Judge Douglas Woodlock of the US District Court for the District of Massachusetts. He holds his JD from Columbia Law School and his undergrad from Princeton. And we are also very honored to have Susan Fender, who is a veteran observer of the Chinese judiciary system and is currently a distinguished scholar in residence at the Peking University School of Transnational Law. Her research interests concentrates on the Supreme People's Court and Chinese judicial reform. And she also is published her blog called the Supreme People's Court Monitor. This blog is widely cited in books, academic journals. So I highly recommend Susan's blog if you haven't read it before. Actually, before Susan became an academic, she practiced for almost 20 years at Freshfield, which is a leading international law firm many of you are familiar with. So without further ado, let me leave the floor to Nathan. And then afterwards, Susan will give some feedback and comments, and we will open up the floor for Q&A. Nathan, the floor is yours.
Thank you, Angela. I'm really delighted to be here today. Your evening, my morning here in Philadelphia. Of course, I'm sorry not to be there in person. I have really fond memories of my last visit to HKU Law School in December of 2018, where I got to give a talk at your center. And got to see many friends, Fu Hualing, Albert Chen, and I just would love to be able to visit again when all the conditions permit. But I'm glad that at least through this virtual mechanism, we're able to chat today. And of course, I'm delighted to have the opportunity to hear feedback from Susan Fender, who I've followed much longer than she even probably guesses, because I started out studying Chinese law at Columbia Law School in the late 90s. And at that time, one of the first articles that I read that helped to really situate my thinking about the Chinese judicial system was her article on the Supreme People's Court in the Columbia Journal of Asian Law, then known as, I think, the Journal of Chinese Law. Yeah, that's but right. Of course, more recently, I've been following her blog on the Supreme People's Court very closely. So I'm really honored that she's here today and will be offering some comments shortly. So I have spent most of my career thinking about Chinese administrative law, starting with the story of Chinese administrative litigation, and then also looking at Chinese administrative procedure reform. So what I have to say today is really situated against that backdrop. And it might be helpful for me to give you a little bit of an overview of the types of things that I've been thinking about in those two areas generally, before getting into what I see as the current situation, and in particular after the Fourth Plenum in 2014. When I think about the development of Chinese administrative law since the 1980s, of course, I put an enormous emphasis on the passage of China's administrative litigation law in 1989, which formalized procedures for citizens to sue the government. And in other work, I've explored how the passage of that law was really reflective of an incredibly open, reformist atmosphere in Chinese law and politics in the 1980s, leading up to that point. And many of these very reformist ideas were memorialized in this law, which very clearly stated that citizens had the right to call out illegality by Chinese government officials, to formally make claims against that, and for courts to adjudicate them. Now, of course, there were various limitations. The kind of review that courts were able to perform was more limited, certainly, than the kind of review that American courts are able to perform in reviewing administrative action, but also more limited than the kind of review that courts in the continental tradition typically can perform over administrative action. But it was still quite an important step in the development of the Chinese legal system. Another thing that was missing at that point was a fully elaborated set of rules about how Chinese government officials should act. The whole infrastructure of Chinese administrative law was still quite in its early stages. And as many on this room or this meeting might know, one of the initial ideas in the lead up to the passage of the Chinese administrative litigation law was the notion of passing a comprehensive administrative procedure code, which would include rules for how government officials or government departments should act in various areas of their endeavors, whether it be licensing or administrative penalties, different substantive areas. And that comprehensive code idea proved to be too politically difficult to proceed with, but there was political space to pass this one part of it, the part that at least allows citizens to sue the government. And the theory was that the mechanism of letting people sue the government would in turn bootstrap the substantive standards that the courts would then be applying vis-a-vis the government officials. And that's in fact what happened, because over the course of the 1990s and 2000s, there was the passage of a number of solitary laws, whether the law on administrative licensing, the law on administrative punishments, the law on compulsory enforcement, and so on, that each of them were sort of told together, made up what would have been the content of that initial administrative procedure code. So over the course of the 20 years or so after the passage of the administrative litigation law, you really had the development of a broader system of administrative law, which included procedural standards. And of course, many people may know that there continue to be efforts to pass a administrative procedure law that would set default standards for how government departments would act, that might be rooted in notions of due process and transparency. And that effort did not proceed as smoothly as the other efforts, but that idea has been in the mix throughout. And throughout this period, there emerged a certain rhetoric about governing the country according to law, administering the country according to law, a rule of law administration, which eventually was, as many will know, was memorialized in the PRC Constitution in 1999. And around all of this activity that so far I've mostly focused on simply what's happening at the legislative level and in terms of the constitutional amendment, there was the emergence of a whole infrastructure, social infrastructure to support this legal development. And what I mean by social infrastructure, I mean not only the professors who were helping to think through the concepts of these laws and actually helping to draft some of them, especially in the case of the administrative litigation law in 1989, but including in some of the later administrative laws. an infrastructure of courts, specialized administrative law courts, which became ever more significant within the apparatus of the Chinese court system, and including at the Supreme People's Court, but lower down as well. Lawyers who specialized in administrative cases began to emerge. And then you had also the development of specialized officials within the government bureaucracies who were tasked with making the rulemakings, the decisions of the government bureaucracies stand up to legal scrutiny. And that, of course, was a development that has changed in recent years a little bit in ways that I can discuss a little bit later, but was very significant on its own terms to have these legal officials that were within the government departments who were monitoring whether or not government decisions, government rulemakings accorded with the legal requirements, would then assist with cases if cases were brought, and of course were in charge of the process of administrative review, which could be a predicatory or a predicate process to administrative litigation. So that's the stuff that I've been looking at and studying for quite some time. And what I think is probably fair to say is that as we reached the end of the prior administration in China, the Hu Jintao, Wen Jiabao administration, there was some concern that all of the developments in these areas were running up against what some Western scholars in particular have referenced as China's turn against law. That's Carl Minzner's phrase, of course, but there were a number of scholars who were suggesting that in that latter period of the 2000s, 2006, 2007 onwards, there seemed to be less emphasis on formal law and formal adjudication as mechanisms for solving disputes between citizens and the government. And there was the rise of what we now think of as the stability maintenance paradigm. So what I think many of us were quite excited to find was that when the new leadership team of Xi Jinping and Keqiang came into power in 2012, there was some new rhetoric about the legal system that accompanied their installment in power that seemed to harken back to the emphasis on the formal legal system and on formal adjudication that had seemed to be missing in the years prior to that. And this rhetoric was accompanied by the appointment of very respected legal figures to leading positions throughout the party-state legal hierarchy. And the paradigmatic example of that, of course, is the replacement of the former police official Wang Shangjun as the president of the Supreme People's Court with the current still president Zhou Qiang, who of course is a graduate of the famous Southwest Institute of Politics and Law, where so many of the leading figures of the Chinese legal reform over the past few decades have come from, and particularly came from that first class, which was full of very many of the most respected figures. So you really had this evidence of rhetoric and appointments to suggest that the new administration was going to take law and formal adjudication much more seriously. And of course, that extended to administrative law as well. This impression was solidified by language in the communique and then the decision of the Third Plenum of the 18th Party Congress, which emphasized the importance of a judicial and structural reform towards accelerating the construction of a fair, high efficiency, and authoritative socialist judicial system, safeguarding the people's rights and interests. And in a judicial reform package that seemed to be indicating that the effort would be to professionalize Chinese adjudication and enhance the status and authority of Chinese judges in exactly the ways that academic reformers in particular had been advocating for many years alongside the development of the Chinese administrative law system. And of course, that trend becomes sort of has its full flowering a couple years later in 2014 with the Fourth Plenum of the 18th Party Congress, which is now known as the Rule of Law Plenum, because it was for the first time in CCP history, a plenum that was entirely focused on legal issues and developed a extensive decision on all the various areas of legal reform, but especially on areas of judicial reform and then administrative law reform that many people had been pushing for many years. And I look at that decision as really a fascinating document because there's a lot going on in it. There are a lot of references to the party in that document. And I remember when it was first issued, a number of people made a number of references to how often the party was referenced in that document. And that might be a concerning signal if your perspective was one of hoping that judicial institutions and legal institutions could develop a greater degree of autonomy in organizing their decision-making in Chinese legal life. So there was that language, but at the same time, there was incredibly comprehensive and detailed references to all the best ideas of the Chinese legal reformers for the years prior to that. Everything that they were hoping to see were referenced in language that if you weren't an expert, you might just gloss past, you wouldn't know exactly what they were talking about. But if you knew what the reformers were actually pushing for and what kinds of reforms they're pushing for, you could see each of those ideas reflected in the decision. And something that I would love to see someday is a history of how that decision was drafted. Who were the drafting people? Because it's a decision which really reflects some different types of themes. I mean, obviously there's the themes about the predominance of the party over the Chinese legal system. And we can have some guesses about how that language got into the decision. But then a lot of language that is really taken from the legal reform community, which of course is mostly centered in the academy, but spread out into other areas of the legal infrastructure as well, including the court system, including the government officials who were tasked with this ruling the country according to law brief. Now, I, at the time, around 2014, 2015, I tended to put more emphasis on the legal reform language in that decision. I thought that the repeated references to the leadership of the party seemed somewhat problematic, but I was really encouraged by the very extensive language on judicial reform and administrative law reform, and noting how they tied to the very specific ideas of legal reformers up to that time. And for example, just in the area of judicial reform, the references in the decision to making hearings the centerpiece of adjudication, to providing more structural independence for frontline judges, for lessening direction by higher level officials over court decisions, by lessening the impact of adjudication committees, all of that seemed extremely promising. And a couple of things that happened shortly after the issuance of the Fourth Plenum Decision. First, not very long after, the administrative litigation law, which I referenced earlier from 1989, was revised. And the revision of the administrative litigation law, which is another topic that I'm writing about, I think is really quite an important moment, because almost from the very beginning of the passage of the administrative litigation law, the reform community that had pushed for its passage was aware of its flaws and were trying to get it revised in ways that they thought would strengthen it, to make the possibility of more fair and effective adjudication of lawsuits against the government more likely. And it's sort of amazing that it actually did get revised, because they were pushing it for such a long time, and it had seemed to not be going anywhere in the latter years of the Hu Jintao Wen Jiabao administration. But now, in the aftermath of the Fourth Plenum Decision, the administrative litigation law was actually revised, and the revision did not contain all of the ideas of the sort of the most bold thinking administrative law reformers in the Chinese legal system. There were many who were hoping to really expand judicial review under the terms of the administrative litigation law to reach not only the particular decisions made by government officials, but also to very robustly be able to assess the legality of the rules upon which some of those decisions might have been based. And the revision didn't go that far, but the revision really does show a genuine concern with trying to reduce official interference in court judgments and enhancing judicial authority more generally, And even on that specific point I just referenced of how do courts deal with the underlying rules that administrative agencies produce, the revision does allow a kind of review of that, which is definitely more robust than what existed before that. And around the same time, the second thing that was happening in the aftermath of the Fourth Plenum was the court system was being encouraged to, in general, move in this direction of having a greater authority for frontline judges, for having less political interference. At the same time, Keqiang was starting to push the notion of having greater judicial transparency and greater professionalization within the ranks generally. So all of this reform ideas, many of which had been referenced in the Fourth Plenum Decision, were actually starting to be seen in reality, and it seemed quite an exciting time. And there's various ways of trying to capture, in metric form, what was the end result of all of these things. But one relatively easy, if simple, metric is simply the rise in administrative litigation cases from the year before the revision, the year after, up to the number of administrative litigation cases has always been a concern of Chinese administrative law scholars. For many years, it had been sort of plateaued at about 100,000 to 150,000 cases per year. And it was often referenced as this was sort of a way of telling that the overall administrative litigation system was not as robust as it ought to be, because it seemed to be the case there were so few. Well, in the aftermath of the revision and in this period of great ferment in terms of reform ideas, the number of cases actually almost doubled, went from about 150,000 cases a year to about 250,000 cases. And it has stayed at that new plateau since then. I just looked at the numbers for 2021. Which of course are the numbers for 2020, but published in 2021. And the number of first instance administrative litigation cases in 2020 was 260,000 cases. So, there was this big jump in the aftermath of the revision of the administrative litigation law, and it stayed at that level, but of course has not continued to increase. So that's sort of where I was in about 2015, 2016. And what I'll just spend a little bit of time now talking in the few minutes I've left, and then can explore more in the discussion with Susan, is how are things going since then? How are things going in the past 5 years? Of course, the last year and a half, COVID has been the dominant story on all of our minds. And so these more technical questions about the provisions in the administrative litigation law or the development of administrative procedure have somewhat receded. But just as the pandemic, perhaps, hopefully, is receding, maybe we can focus again on these kinds of questions. And frankly, I think there's a lot to be concerned about in terms of what's happened in the past 5 years. And let me say a few things about some of the types of things I'm concerned about first, and then maybe offer some thoughts about what's going on in the background. And one of I think the main thing that I'll reference as a concern is how the movement to make judges and courts more professional, more independent, have more authority for frontline judges, to have more authority for the court system within the overall decision-making apparatus, has seemed to shift towards a greater emphasis on judicial discipline. So it's less about we are trying to empower judges by making sure that their professional qualifications are extremely high and that their ability to make decisions is extremely safeguarded, and the possibilities of political interference are extremely limited. It shifted more to, if judges make a mistake, they're going to get in a lot of trouble. And Susan, of course, has written about this recently in a chapter that I recommend to all of you on the judicial discipline. And many of the scholars that I think were very excited about the possibilities for professionalization and empowerment of Chinese judges in the period that I was referencing earlier, 2013, 2014, 2015, I think have become extremely discouraged by the way in which that has sort of shifted towards, well, we're actually going to put more emphasis on making judges feel afraid that if they make some kind of a mistake in their judicial decision making, then the penalties will be quite high. The other thing, of course, that we've seen in the last few years is the rise of the National Supervision Commission. Of course, that ties together with the overarching anti-corruption drive. The National Supervision Commission in some ways is like the legal formalization of the anti-corruption drive, which is another avenue for accountability of government officials that is less driven by the types of ideas that drove the administrative litigation model of government accountability. So the National Supervision Commission model is not as dependent on citizen input. It is less to do with particular instances of illegality that citizens encounter, and has more to do with the priorities of the top, of the center, which frankly often have a political tint to them. And of course, that has become sort of the big story of Chinese administrative law of the past couple of years, is the development of this National Supervision Commission apparatus and all of its implications. The other thing that's happened that is a little bit in the weeds, but I think is significant, is that the government legal affairs offices that I was referencing earlier, which were an entire apparatus or an entire shitong under the State Council Legislative Affairs Office, that ended up getting sort of combined with the Ministry of Justice in ways that are still very confusing, and for reasons that I think are still very hard to discern. And so the Ministry of Justice, which has a wonderful and very fancy name, but really had increasingly limited actual things to do that pertain to the operation of the judicial apparatus or of the formal legal system in recent years, suddenly now got all of these people who were part of the very, very well-developed legislative affairs, legal affairs apparatus in the government up to that point. And it's unclear that the attitude that they had prior to that merging, and the roles that they had prior to that merging, the responsibilities that they had were preserved after that merger. I know I only have 2 minutes left, so let me just say a quick thing about sort of the way that the theory that I've been developing about how things are developing, and then of course we can talk more in the discussion. What I've basically tried to understand is what happened. What happened about 2014, 2015, 2016 and onwards that seems to have shifted the direction of legal reform. And the best that I can come up with is that there really does seem to have been some kind of political impetus in the early years of the Xi Jinping, Li Keqiang administration to take law more seriously, to think of formal law, formal adjudication as useful tools of governance, and to empower legal reformers to try their best to strengthen that system. And for reasons that I don't fully understand, that political energy dissipated after the Fourth Plenum, or at least it changed. It changed from a perspective of empowering the legal reformers of the earlier decades, and changed to one of the priorities of a center party state, and that change is visible. Why there was the initial interest and the formal legal system, formal adjudication, and why that has shifted towards this more robust emphasis on political considerations now, I don't know. I don't know if there was some kind of empirical reason for that. I don't know if there was some kind of theoretical reason for that. But the energy that was driving the reform spirit of 2012, 2013, 2014 has dissipated. So that's one claim that I'm exploring here. And then the second claim is simply, well, then what happens to the ongoing apparatus of reform after the energy behind it has shifted? Because law in any society, whether it's American society, Chinese society, continental, a law is sticky, and you sort of set things in motion. It's often hard to stop them, and they build up and they have different layers as time goes on. And so it's unfortunate, of course, that, as I've been claiming, that the political mobilization behind support for the legal system seems to have shifted or turned off. But many of the projects that were set in motion by that energy or empowered by that energy still kind of continue. And that's why I use the terminology of zombie legal reform. So it's zombies, they still kind of exist, but the animating life has been drained out. And we can see that, for example, in things like the Supreme People's Court, the efforts to put cases online, to be more transparent about judgments. Those types of things still exist. The website still exists. You can still go and look at those cases, but it has not continued to develop in response to concerns and critiques in the way you would think it would if the political mobilization was still behind it. And the last question that I'll sort of close with here is simply, well, what do we make of zombie legal reform? Does zombie legal reform go anywhere? And is there a possibility that zombies can be brought back to life under different conditions in the future? That's something that I'm certainly going to be very interested. But let me stop there, and I'm very happy to hear Susan Fender's comments and critiques.
Susan, you're not.
Yeah. Okay. Yeah. Thank you. Okay. So before I turn to commenting on Nathan's presentation, I want to say two things about Angela that hopefully nobody else has said. The first is thank you for inviting me. I think most people don't know that I have a very long-term link to the Hong Kong U law faculty, and I'm a former colleague of a number of people on the faculty, including the current dean of the faculty. So thank you. The second is what I would call a collective thank you, because I think you're the person who has established this international speaker series, on China's law and economic governance. And this event was promoted through the Center for Chinese Law's WeChat account. So these two things don't seem like a big deal, but I think in these pandemic days, they're a stealth big deal, because it's impossible to meet, for a conference. So this way, it's a way for us to meet virtually, even though we can't, have the small chat over the food or the tea or the coffee. And so promoting it via WeChat, it's possible for Chinese, whether it's my students at STL, or Chinese judges or prosecutors or other legal professionals, to listen and to speak up. Yeah, no need to get, to apply for a passport or a, or a Hong Kong Tongxinzheng, right? You can have this back and forth, from the comfort of your home. So I think this is, a big clap for me for establishing this. I guess then turning to Nathan, thank you for doing this event and putting out a big topic for us all to talk about, and, to come together in this virtual room. Especially in these days of, rather cool relations between the US and China, although hopefully not between Americans and Chinese people. So, so I think, a big thank you to him for that. So this, your presentation reminds me a bit of a talk I gave about 3 years ago, when Judge Zhang Huiling was still head of the FIANCE, the China Institute for Applied Jurisprudence, where I was asked to assess judicial reform, in Chinese with people from the Judicial Reform Office in the audience. That was like the most stressful presentation I've ever given. Yeah, so I think one of my first slides was the picture of the elephant and the blind man. And so I was querying whether I was able to see all of judicial reform and provide a decent assessment. Okay, so turning to your presentation. So on administrative procedure reform. Okay, I guess my remarks, take with a grain of salt because it's not my area of law. There is a Fazhi Zhongfu 5-year plan, so 2015 to 2020, that has some kind of administrative procedural reform in there. I assume on somebody's policy drafting stove, there is a 2020 or 2021 to 2015 to 2025. I assume there's another plan coming out. So that's has more on Fazhi Zhongfu, because there's the goal of having, I think there's a long-term goal of Ifa, Xinjiang, et cetera, by 2035. So a big part of that is having the government do things more according to law, right? So there should be more in there. But let's see. I guess I did some searches, preparing for this, and I guess like an academic study I saw, written by people at Zhangfei said that the progress so far has been uneven. Some places better than others. Yeah, and I saw maybe the Ministry of Education's progress report on their Fazhi Zhongfu. What else do I want to say? I think in addition to the the transformed Fazhi bond that's now in Sifabu, there's also these Gongzheng Lishi. Yeah, I was chatting, so I was messaging a guy I know in Guangzhou who's one of these Gongzheng Lishi. So he's part of the system because he said he's the sole client of his firm is the government. They can't do any commercial matters. He said all of Guangdong has the system. So but he said it's hard. He said it's hard to, Tweeguang to have roll this out nationwide. So I think things are happening a bit, just kind of below the radar in terms of this, Ifa Xinjiang, to have better consideration of legal matters in governance. So I think there is that piece. Okay, now shifting to kind of judicial reform. What do I want to say? Definitely, of course, there is a stress on judicial responsibility, but according to a survey I did a couple of years ago by Hu Changming, who I've written about, he's a scholar at CAS. So the responsibility system wasn't the top factor in people deciding to leave the judiciary. It was the whole benefits, the Dai, with dissatisfaction with judicial reform in there, but not as a top factor. I don't think he has updated the. I don't think he's updated the survey, and the numbers on how many people are left, I think, must be locked up in a safe, in the Supreme People's Court, Zhengzhibu, right? I mean, we haven't seen those numbers. So I think it's the responsibility system isn't number one. Yeah, and then also, I guess, still on the people leaving, he found way more men leaving. I think it was a cohort of, I think, maybe 70% men who were leaving versus 30% women. So I think I kind of see this when I go around court. There are quite a few women. I think the women are better, a lot of women are concerned about stability in their lifestyle, right? Because they have multiple jobs to fulfill. So I think we're seeing more female talent in the judiciary. Maybe more men are leaving, although the Supreme People's Court is making it more difficult for people to leave because they've tightened up irrelevant regulations. I think I know if you drill down into the fourth and the fifth judicial reform program, there are a lot of reforms that have been put in place. I mean, even in the area of more autonomous judicial decision making. And for example, there's the what's it called? The professional judges meeting. So, and the system of having the head of your division sign off judgment, that's been abolished. So my guess, I haven't seen the numbers, there are fewer cases going up to the judicial, right? There are a bunch of cases that will always go to the judicial committee by judicial committee regulations. But I think a lot of issues where judges aren't sure, they're resolved within their own division. So they're resolved among colleagues, and it's not a decision required of them. That's my perception, right? Because there are millions and millions of cases. So, I mean, for those ordinary cases, I'm not talking about special cases. Yeah, and also from my interactions with friends who are judges, they're always very frequently having to attend those. And plus my students who are interns, they're often taking notes at these So I think there is more of this, there's more autonomy concerning professional matters at the same time that party leadership is being strengthened. Let's see what else. How much do I have more time? Am I okay this time?
You're okay, Susan.
Yeah, okay. Yeah, I'm conscious of not wanting to go on. Yeah, and so I guess other professional, kind of professional reforms, have gone on. So it was like the similar case search. That reform, so that reform has, gone into place officially last year, right? So that's a discrete, important professional reform. As to why some reforms haven't been, I know I think an article, or maybe not a book, but I think the drafting of judicial reforms and the implementation of judicial reforms. I think there's an academic article there, because I think it's much more complicated than than most people. I think Lawai or Laone, I think it's much more complicated than we think. Okay, let's see, then, yeah, so I have some thoughts about this judicial reform process, but they're not, not fully formed, so I'm not going to say too much more about that. On administrative litigation, what did I see? Yeah, like the SVC just came out with another set of regulations, including ones on checking, what is it? So what on the qualification of local government. So like, I think it's what is the Sheiji the Difeng Zhengfu. So I think this is related to the rural revitalization, and land takings at the, at the village level. So I think, so administrative, it hasn't died. It's also, in my view, rather complicated. So Angela, I checked with Angela before this. She said very few anti-monopoly cases are challenged in court, right? Like the US. Let's see, I've found an article of tax. There are more and more tax cases that are being litigated, but half of those are individuals. Yeah, because I think businesses are loath to challenge regulators who will be regulating them generally. Because I remember this from having a chat with a guy who was agent general counsel for, I think it was a medical device company. He said, we'll pay the fines. We don't want to piss off our local regulators. So I think where administrative litigation works, they need to look closely at different types of data. The other thing I would say is that there's stuff that goes on behind the scenes between courts and government that we don't see. I think I mentioned it actually in my article 30 years ago, where sometimes administrative agents will come to the courts and say, will this work, right? Plus you have the SFA-JE. So that's also a way for the courts to push back. So I think you can't just put the litigation-centered model of the US into China. I think it's a more subtle kind of relationship. What else? Yeah, so I think I'll stop here, but thank you for opening up this big box for us to discuss. Big box of, Christmas in May, right? Big box of issues to discuss, and I'll let other people, join with their comments here. See, Albert is in attendance, and lots of other people I know. So I'll let them, I'll let them add their views.
Angela, can I just make a couple of quick responses?
Yes, please.
And I see Albert. I would love to hear from Albert, and I see some other friends too in the chat that would be lovely to hear from. So I'll keep this very short. And just first of all, to thank Susan, these were very helpful. And I think your last point about trying to be careful not to overemphasize the American litigation model, and when we think about China, is very well taken. And that's a deeper conversation that we can develop later. But the main thing I just want to emphasize is that the takeaway from your comments, I think, is that there continues to be movement on the reform agenda, both in terms of administrative procedure and in terms of court reform. And I want to agree with that. I'm not saying that legal reform in either of these areas is dead. I'm calling it zombies. And zombies still keep going forward. They keep going forward, but they don't have the same animating life as they used to. And I'll give one quick example of in one of the areas that you talked about. So the administrative procedure reform, and I've got to be careful not to go too deep in the weeds here, but there was this movement towards passing a administrative procedure law in the early 2000s that would set up default standards of participation and transparency in the way that Chinese agencies operated. And very famously, that got presented by some legal scholars to the NPC Legal Affairs Commission in the early 2000s, and they didn't get through. It didn't work. So it was considered a failure. But a lot of those ideas were reflected in the State Council's 2004 outline on comprehensively building government according to law. And the aftermath of that outline, Hunan province, which at the time was led by now SPC President Keqiang, passed a local administrative procedure regulation at the level of a guizhang that actually contained many of the ideas that the legal scholars had been trying to get in a national legislation up to that point. And after Hunan did that, a number of other provinces started to pass guizhang that were sort of modeled on that idea. And the national legal scholars were quite excited that perhaps this proliferation of these guizhang at the provincial level might eventually bring a new pressure for that kind of a law at the national level. And as I've been tracking that since the early 2000s, another thing that sort of happened was that the legal scholars were like, okay, well, we're not getting much traction in terms of getting a national legislation, but maybe we can get these provincial things at the higher level of a fagui so that it has even more impact. And it was all also tied up with the ongoing development of the Fazhiban, the legal affairs offices. And so the legal affairs offices were getting more power under the terms of these guizhang, but they were hoping maybe fagui to sort of do a legality review within the government department. This is all too much detail, but the main point I want to say is that effort has basically been channeled now into much more constrained language and a much more limited vision that is in that reform program that you mentioned, the new outline. That spirit of what the goal was and where this was all going towards has dissipated, and it's only recognizable at the surface level in some of the terminology. And so, yes, it's going forward, but it's not being pushed forward by the same animating spirit as before. And with with judicial reform, I think one could make a similar argument that yes, that technically there's continue to be precise things that are being pushed forward, but the animating spirit of why we're trying to do this and the political environment of we're trying to do this precisely to make judges feel more empowered within the overall political system, that animating spirit has gone. And as we know, anything from the development of Chinese law over the last 30 years is simply like the technical rules is not enough. You've got to have the political impetus behind it to support the new authorities that the technical rules are trying to offer. Otherwise, it doesn't go anywhere. And so that's the basic idea that I'm trying to capture in this project, which is, yes, we still see some ongoing residue, and we can call it reform, but it no longer has the animating spirit that it had in an earlier period.
Fantastic, Nathan. I mean, I love both your presentation and Susan's feedback. I know Albert is here, and I very much want to hear from Albert, but I want to take the privilege of being a moderator to jump in and offer a couple of comments as well, because I'm super excited by when I was reading your paper, and mostly because I have been working on a number of other projects that are not related to administrative law at all. But what is fascinating is what I found is that we've identify very parallel trend in terms of the Chinese policy. Because if you think about, law simply in China remains still an instrument to advance policy goals. So it's not so different from looking at economic policy or financial policy. It's just another policy for the Chinese Communist Party. And what I found interesting is that we found parallel trend. And in my research, I found parallel trend with both economic and financial policy, because these are the areas that I specialize in. What I observed is since Xi came into power, when he first came to power in 2012, as you may recall, there was a lot of talk, very encouraging rhetoric about economic reform. Let's deepen economic reform. So every day, Li Keqiang was talking about economic reform. And between 2012, 2014, we saw the government aggressively push forward a lot of initiatives. I'll give you a few examples, like the mixed ownership reform, privatizing some of the state assets. They were also toying with the idea of let's get rid of SASAC, which is a state assets regulator. Let's create something like Singapore. Let's do a TAMASAC to manage our state assets. Right? In terms of the financial regulation, the securities regulator introduced many initiatives such as making it easier for companies to make acquisitions and making it easier. Let's make it easier for private firms to borrow. So they allow private firms to mortgage their securities to those securities traders, so they can borrow more money to finance those acquisitions. But then things began to turn sour very quickly. As you may recall, the first sign of things getting bad is in 2015, there was a huge stock crisis. And then there was increasing worry about that crisis in China. And then you saw, starting from 2016, the government started a massive deleveraging campaign, tightening finance. And that have follow a lot of policy that you saw from the Xi during the second term, right? Tightening party control over various areas of the finance and economic system. Calling for state-owned firms to enhance party building, amending the corporate charters, those kind of stuff, more and more of those stuff, and even initiative to push a tighter control of private firms. And then Donald Trump went into power, and then you saw the relationship become even worse between China and the United States. And then you saw this direction further tightened. So inevitably, what I saw, in between the reversal of the legal changes and the reversal of the economic and the financial reform in China, they went really parallel to each other. And they seem to reflect a trend of the insecurity of the Chinese leadership. I don't think anything that Chinese government nowadays doing is politically ideological. I think the Chinese government is actually very pragmatic. When they're very secure, they do push for more reform, because reform does brings about prosperity, economic vitality to the society, right? This is something the government wants. But then the government is also inherently insecure, because when they see things going in, they're seeing some side effects from the reform. Right? I could imagine, like, if we give more autonomy to judges, maybe judges might make more mistakes, right? So there could be some potential unintended consequences resulting from reform, which is something you see from economic financial reform, because it leads to heavy debt prices and stock prices, right? The party is concerned about instability. Then the party quickly switch and from opening to tightened reform. And I wonder whether you agree with me, this overall trend is actually reflecting the overall political and economic environment, and including also the China's relationship with the rest of the world as well. And if you agree with that point, then I think it helps answer the question that you ask, what is going to happen in the future with China's legal reform? Because that kind of predict, if the relationship between China and other countries continue to be very tense, you might see, it's unlikely to see the party will losing control, because the party will still want to continue mobilize control in every single respect in order to deal with crisis, whether we're talking about economic crisis or political crisis or geopolitical crisis. So yeah, I would love to hear your thoughts and feedback in response to these comments, and then I've opened the floor for Q&A.
Sure, that's really important. I also see Albert put a question in the chat, which I think is really important. So I don't know if we can get him to
yeah, Albert,
one or another. We can convey that as well. I just think I would love to. How long can we go a little bit longer so we can capture
we can
all
go a little bit longer as well. Yeah.
Okay. Let's see. Okay. Let's see whether. Okay. Yes, it's nice to see all of you here, and thanks to Nathan and Angela and Susan for your presentations and comments. So as I have written on the chat box, the Chinese scholars whom I have been in touch with were generally feeling that there's some kind of decline or regression in terms of legality of rule of law in recent years. And we also know about the tightening of controls on freedom of expression, the campaign against the Weiquan lawyers and so on. So I want, but on the other hand, there seems to be more legislative activities at the level of the NPCSC or NPC than before. My friends at the NPCSC seems to be busier in law drafting, and they have to produce much more legislative documents in recent years than before. So I wonder, what is your assessment of the trend? Are there conflicting developments, or is there an overall trend which support the more pessimistic assessment?
So Angela, can I maybe respond to you and Albert just while these two? So both really important and very helpful comments. And so just briefly, I think first, Angela, I'm so glad you mentioned the stock crisis from 2015, 2016, because I think that was really quite significant. And I think it's underappreciated outside of China, how much that impacted the thinking of the top leadership. And not only on sort of the direction of economic reform, but also on their assessment of, just stability. We know that this ongoing concern about stability is the sort of the driving thought of this particular administration, but prior administrations as well. And I think it shook them up. That's everything that we're, obviously we're not, this is not the most transparent sort of system to peer into, but the reporting that we've seen has suggested that they were really quite shaken up by that. And I think that sense of needing to solidify control, which was already in place before that, only strengthened in the aftermath of that. And I agree with you also that the wider sort of tensions only sort of reinforce that. So, there may have been, in my sort of theory of it, there may have been people who convinced the top leadership, or even she personally in the early days of the administration, that empowering the legal system generally could be an avenue towards stabilization. You no longer would have all these petitioners kind of massed up against, these various government departments. You would have them go through the court system instead. In my imagination, that's an argument that was made, and it was like, okay, let's try it. But the concern about stability maintenance, I think, got to a point where the decision was more, no, we're going to go towards the control model across the board. And then that gets to Albert's question, which I think is really interesting and important, which is how, this idea that we have lost the energy of the direction of legalization and towards, some kind of quote unquote rule of law is widely shared amongst not only Western scholars like myself, but many of our Chinese scholar friends as well. And so, Albert's question is, what are we looking at empirically to show that? And sure, I think we could reference the tightening space for the Weiquan and all of that, but frankly, there was a tightening space for a long time. And, I don't know that that is what I would lead as like the number one example. To me, the thing that Albert's question really has solidified in my mind as an answer to this is the metric that I think is really important is how many additional actors beyond simply the party state's core actors are being empowered by the institutions that you're creating. And when you look at the direction that things seem to be going some years ago, you were seeing the empowerment of courts, you were seeing the empowerment of the Fazhiban, the legal affairs offices, you were seeing the empowerment of lawyers, maybe not the Weiquan lawyers necessarily, but lawyers who were taking the somewhat less controversial cases, and also the government lawyers that Susan mentioned earlier. So you had this multiplicity of actors in the system who all were able to have a piece of responsibility in this apparatus that was being constructed. And that's, that is, regardless of what kind of rule of law language we want to use, what law sort of offers the hope of is that it's got its own set of values and its own autonomy that's separate from political considerations. And all of these different actors within that are helping to shape the actual practical results. And what I think we're seeing in the last few years is less space for that we're seeing the control apparatus crowd out the autonomy of all of these different actors within that system. And again, I'm not talking about cracking down on Weiquan Lusher. I mean, that's an important metric, but that's not the metric I'm talking about. I'm talking about, do the professors get their ideas pushed forward? Do the courts have the authority to make the decisions? Do the government legal affairs offices, which now no longer even really exist, they're within the Sifabu, do they get to go to the government officials and say, listen, you can't do this because this would be a violation of law? That's the metric that I think is the most important metric. And it's because of the decline in autonomy in all of these respects that I think most people would say that, yes, there's been this decline of legalization, even though, Tom Ginsburg and Taisu have this big article in the Virginia Journal of International Law, which, takes the argument that all this stuff we're seeing is legalization, and, it is continuing legalization. And I think, just to close, I know I tried to throw in a scholarly debate at the very end of my comment here, but the one thing for those who are aware of that article, my big response to Taisu and Tom is that they don't have enough confidence in what legalization could look like if you're empowering all of these different figures within the system beyond just the control attitude of the central government.
Excellent. Thank you very much, Nathan, and thanks, Albert, for your insightful feedback. I wonder if any of our participants will want to ask any questions at this point. If not, because we already is likely over time. I actually have many other questions that I could pose to Nathan, but I don't want to get in people's way. So if we don't have other questions, then
I do see a couple in the Q&A.
Really?
I don't know if you want to.
Oh, is it Q&A? Oh, sorry. I'm so sorry. I didn't see the Q&A. Oh, sorry about that. Oh, I'm so sorry. I didn't see the chat. Okay, so let's start with Fidi's question. Thanks a million for Nathan and Susan. My name is Fidi. I am a PhD student at the Faculty of Law at HKU. I have two questions. My administrative procedure law teacher once told me that 1989 is the corner for the development of administrative procedure law because it's quite tricky that this piece of law was passed before the Tiananmen Square protest. Did you spot a second corner for the development of this piece of law? Did you notice any case that could be regarded as a milestone in this field? That's a very interesting question. Nathan, would you like to respond to this one?
Sure, and I know I'm fine on time, but just because of, I know you might be, so I'll be very quick in some responses. And so on this one, the main thing I want to just say is how much I agree with that initial point, that it's really remarkable that the administrative litigation law was passed in 1989. And I have heard from many people that if the legislative process had been delayed, so that they had not passed it in April of 1989, it's very unlikely that it would have been passed later. So it is really quite remarkable that it was passed when it was. And again, I do think it's a reflection, it's sort of a formalization of a lot of the legal reform thinking prior to 1989 is in that piece of law. And when the question of the second corner, many people thought the revision was that anticipated second corner. So that hope of the revision was going to be that the revision was going to be the next sort of move in the development. And so the other paper that I'm writing about the revision basically tries to compare the way that these legal texts, these legislations reflect the times that they come from. So the Administrative Litigation Law in '89 reflects its time, and then the revision in 2015 reflects its time. So I'll have more to say about that shortly. And in terms of the cases, I would be curious if Susan has a reflection on the cases. There is the one case, the very famous case that is slipping my mind now, that Lo Ha-Tsai was on the panel for, and it's regarded as a milestone. But I mean, I don't know, frankly. I mean, in some ways, I think the real milestone cases were the cases for the passage of the Administrative Litigation Law, in which you first started having courts accept these kinds of cases and make judgments. There was one case in the aftermath of the revision of the Administrative Litigation Law in which it was the IP court, and again, we don't have enough time to go into the details, but the IP court made a decision that seemed to be formally saying that a regulation was invalid. And many people thought that that was opening up the channel for courts increasingly to take that possibility, which is somewhat anticipated in the revision, but not very robust. But as far as I can tell, that hasn't really manifested itself as a robust thing of courts really explicitly saying that the underlying rules and regulations that government officials might be applying in cases are invalid. But if we did have a case like that, that would be a big deal.
Right, Susan, do you want to chip in, or we can move on?
Yeah, no. On the last point, I thought I saw there was a relevant article in the SPC Administrative Division's publication. So there might be more data there, but I've just seen the name of the article. I haven't read it. But no, because I guess there's not that much more I can add on administrative litigation.
Cool. Okay, let's move on to the next question. So Luo Jiajun mentioned, like, many thanks for the presentation and discussion. So the judicial system, along with other aspects of China's legality, has become more extractive instead of more inclusive. I'm not 100% sure about the question. So Nathan, what do you think?
Yeah, I'm not sure what extractive means exactly.
Exactly.
So I'm a little confused by it. I think in general terms, though, most of the discussion so far has been focused on, I think, what the question's getting at. So I'm not sure I have too much more to add to that.
Right. So, the part, actually, how come there's Hua Ling's leaving a comment with a name called Audrey Fu? Oh, maybe he's signing in with his daughters.
That's what I thought.
Hi, Audrey Fu. The party cannot be controlled, but can party be judified?
That's, I mean, you know, Hua Ling always asks the best questions and the deepest questions. And, you know, I think I would love to spend some time thinking about that. It does, and I'd love to hear what Susan has to say about this, and you, Angela, and Albert. But the one thing that jumps to mind is it reminds me of the way that people were talking about intra-party democracy some 15 years ago. Remember, they were talking about, okay, well, there might be elections within the party. And, you know, that didn't really seem to go anywhere. So I'm not sure juridification of the party, my instinct is it's unlikely, but I would be curious if others have more imagination on this point.
So food for thought tonight. But one last question from SK Lee. Is China more prepared to adopt a Western style of judicial process in foreign-related commercial matters? I'm thinking of reforms like CICC, the Foreign Investment Law, and special measures piloted by China in Shenzhen and Greater Bay Area. Would these reforms, if successful, be radiated to other parts of China?
So for this, I really will defer to Susan because Susan's been writing a lot about these courts, and I'd love to hear her response. My short notion is, regardless of whether they work on their own terms, which we're about to hear from Susan, I don't know that I think that it's very plausible that it will radiate to other parts of the. I think they are somewhat segmented from each other. But Susan, I'd love to hear what you say on this.
Yeah. Okay. So CICC is. It's part of the SPC. It, for the most part, I mean, there are some innovations, but when they drafted the rules, they were restricted by current civil procedure law. So there's some minor. So I know the other question is, what is Western? So it's definitely a slightly amended version of Chinese civil procedure. They've adopted, what was this? Was it like a case meeting? They've adopted some things from arbitration. So they've because a lot of smart people, they've figured out things that would work, that would fit within the rigidities of the civil procedure law, and work in the Chinese system. Actually, the Belt and Road Opinion 2 does talk about replicating the CICC in other parts of the country. There's a new Suzhou International Court, but I'm not sure. I know it was just set up and they have their bunch of of experts, but I've not seen the rules. And Hainan is working on something also. Well, but I had not seen any kind of substance. So it remains Chinese civil procedure. I mean, there's the new evidence rules, I think, passed last year, working on Chinese style discovery, so better discovery, or, exchange of evidence than, but I mean, do you call this Western style? Or, I think it's going towards kind of international standard in that way. So with the foreign investment law, I mean, that's in force all over the country. So the Shanghai court has certain innovations there. It's all within the restrictions of Chinese law, and then, all courts are under party, right? All courts are under party leadership, right? That's how we want. But I mean, yeah. So, assuming that's not part of Western style.
Angela, just before we close, I want to note that Albert has put a response to Fu Hualing's question in the Q&A. And so Albert writes, there's a definite trend of increased enactment of intra-party regulations. And so I agree with that, and I think that's important, but this is a longer conversation, but to me, the question is, does that count as juridification, right? We can talk about how the party continues to kind of have mechanisms that they're trying to develop to control their cadres better. But does any of that count as juridification? I think at least you'd have to have some kind of a disciplinary process emerging within the party. I think the way to answer Hualing's question is, can we see a disciplinary process emerge within the party that seems relatively juridified as opposed to politically driven. And I don't think we're going to see evidence of that.
But there is some kind of like 审判史 in the disciplinary proceedings. What goes on? I mean, I haven't looked, I haven't drilled down to know. Yeah, and hold on. I mean, and you don't get, I don't think you get a lawyer or any representative. I mean, I have to check back at, because I had a blog post a couple of years ago, which touched on these things, because money, property can be forfeited, or it can be asset forfeiture under these proceedings, right? So it is important, but I don't think it's not a full trial, right? And certainly not publicly available. But the other point I wanted to add on the juridification part is with the merger of administrative agencies into party organs. Yes, there were. It's an issue like the movies or things. You know, it's all taken over by the Shenshangbu. But I don't know if there's a regulation. Anyway, I've seen so there's an article in the SPC Administrative Division's journal to say that if like the Shenshangbu is, if it's regulatory functions such as licensing, that the courts can take those kinds of action. It can accept those cases. I haven't followed up to see whether those cases exist, but I assume so. So a bit of juridification.
Right. Well, we have a couple more feedback from our audience. Nathan, were you able to see it? But I'm well aware that we are way above time. It's almost 9:23. So I will, I guess, Nathan will take this feedback with you on the juridification issue, which is fascinating. And thanks, Audrey Fu, for raising that point. And okay, so with that, let me end today's talk. And it's actually the last talk for the semester. And I'm really excited that the students actually spend some time outside their exam, because they're having exam right now, to come to the talk. And I hope it's refreshing and you have some takeaway with you. And I do learn a lot today from Nathan and Susan, Albert, and Audrey Fu. Okay, so I will see you next semester. We will have another round of workshop, and I promise it will be fun.
Oh, thank you. Thank you to all of you too.
Thank you so much for having me. It was wonderful to be with you. And I just want to say there's someone who's responding to Q&A. I don't know if it's the person I think it is, but if it is, it's great to see them. And I'm so pleased they were in this chat. It would be really an honor if it is who I think it is.
I think it is.